Hello and welcome to the Hub International ERISA 101 training webinar series. This series is designed for employers and others who want to better understand ERISA's basic obligations. My name is Carrie Cherveny and I am the Senior Vice President for Strategic Client Solutions for the South Region, and I am your presenter today. Please be sure to review all of the sections of this ERISA 101 training webinar that you can see listed here. They are all available on hubinternational.com. In this section, we will be covering the specific requirements of an ERISA plan. There are several ERISA document requirements. In this session, we will talk about each of the following documents in more detail. As an overview, employers must be sure that they have the plan document, which is also known as the wrap document, the summary plan descriptions, or some plans may call it the summary plan document, a summary of material modifications, which is created in response to certain plan changes, the Form 5500, which is tied to the employer size, and the summary of annual report, which goes with the 5500, but only under certain circumstances. It's important to know that there are also a number of notices required by ERISA, which we cover in Section 2 of this series. Each ERISA plan must have an underlying plan document. The plan document provides important details regarding the terms and conditions of the plan. It's generally a long document filled with legalese. In my day, it was a 4-inch 3-ring binder that sat on my bookshelf and collected dust. But the Department of Labor knows that employees are not going to read this long document filled with all kinds of legal jargon and may not even understand its contents. Therefore, ERISA requires that employers provide employees with the summary plan description, or the SPD. The SPD is essentially the Reader's Digest version of the wrap or plan document. I'm going to cover the SPD in more detail in just a couple of slides. Often, a carrier will provide a document called an SPD or a summary plan description, but it's important to know that the carrier document does not satisfy the employer's SPD obligations. Let's first start with the wrap document and its requirements. Imagine if you developed a plan document for each and every ERISA benefit plan you offer, including dental, vision, health, life, short-term disability, long-term disability, voluntary plans. That can get arduous and complicated really quickly. Fortunately, the Department of Labor actually helps us out by allowing employers to take all those individual ERISA plan documents and wrap them into one. That's why it's called the wrap, like a Christmas present. Wrap it up. The purpose of the wrap is to combine all of the ERISA plans into one document, and there are essentially two basic ways to build that wrap document. The first is to rely on the underlying carrier document and build the wrap that includes only the employer required information that's missing from that carrier document. The risk with this approach is that it assumes that the carrier document is 100% correct, up to date, and compliant. The second approach is to work with a vendor that develops your wrap from a customized document built for you. Regardless of which approach you choose, it's important to know that the carrier document alone is not sufficient and will not satisfy the employer's wrap and SPD requirements. It's likewise important to know that all employers that offer ERISA plans are subject to these rules. The employer size is irrelevant and does not matter. If you have 5 employees, 50 employees, or 500 employees, you are obligated to provide an SPD to your employees for all of your ERISA plans. To wrap or not to wrap? That is the question. Wrapping all of your plans into one document is certainly administratively easier. In that case, you're managing one wrap, one SPD, and you have far less moving parts and a lot less paper to hand out to employees. However, when you wrap all of your plans, if just one plan becomes subject to the 5500 filing, which I'm going to talk about shortly, then you will have to file a 5500 for all the plans that are included in your wrapped document. Practically speaking, at least for hub clients, we rely on vendors to complete the 5500, so this doesn't represent a real increased administrative burden for the client. Earlier, I explained that the wrap document is a long document filled with legalese, and consequently, employers must provide the summary plan description, or SPD, to employees. More specifically, the SPD must be written in a way that will be understood by the average person, usually someone with an 8th grade reading level. Additionally, if you have a significant non-English speaking population, you may be required to offer translation services or other language assistance to your employees. The language of your SPD is extremely important and is a key component in any lawsuit or litigation against the plan. Therefore, if the SPD is considered vague or ambiguous, it will be construed against the drafter. I also want to provide just a little more information regarding the contents of your SPD. I referred earlier to the carrier documents. Many carriers create and distribute template SPD or summary plan description documents. These documents usually contain generic carrier language that satisfies certain carrier disclosure obligations. However, it does not contain the employer-required information such as plan name, plan sponsor, EIN number, eligibility rules, COBRA qualifying event rules, etc. In fact, there are actually more than 50 mandatory elements to a wrap and SPD that go beyond the information contained in the carrier document. Therefore, employers must be sure that regardless of which approach they choose for their plan documents, that those documents meet the ERISA requirements. So we've talked about the documents, the contents, and the structure. How about your obligations to deliver? There are very specific rules around the timing associated with delivering these documents. The SPD must be distributed at certain specific times in the employment relationship. It must be delivered at least every 10 years if there are not any changes to the information and contents of the SPD. Now, this is really, really unlikely. Even if the employer is not making any changes, the federal government continues to require changes to SPD language. So when there are changes to the contents of the SPD, it must be provided at least every 5 years so that the document memorializing the changes, called the Summary of Material Modifications, is distributed within 210 days of the plan year in which the change occurred. There's also an escalated rule when the changes materially reduce coverage. This sounds arduous, it sounds complicated, it sounds difficult to manage. So I'm going to give you what I'll refer to as an SPD hack. Many HR professionals adopt a more streamlined, efficient, and conservative approach to delivering SPDs. They hand out an updated and current SPD at every open enrollment. They do this to ensure that they're more than exceeding the obligations to comply with the 5-year cycle, and they don't have to worry year over year about where they are in that cycle. In addition to the ongoing obligations to deliver, employers must also provide the SPD to newly enrolled plan members within 90 days of enrollment. If you happen to have a new ERISA plan, meaning you've never offered it before, you must hand the SPD out within 120 days. They give you a little bit more time to get that SPD built for brand new programs. And most importantly, If a plan participant requests that SPD, you have just 30 days to provide it to the participant, and the DOL is very strict on that deadline in particular. We've talked about the documents that are required, the contents of those documents, and the timing for distribution. But wait, there's more. ERISA also regulates how you deliver these documents. The default rule is hand delivery or mail to the home. When you rely on the default rule, your obligation is merely delivery. Therefore, it's a best practice not to use certified return receipt mail. If you're handing documents out at a meeting, it's a good idea to have a sign-in sheet. Save the sign-in sheet along with the documents you handed out in the event that you ever have to prove delivery to an inquiring mind. The biggest question I get all the time is, can I deliver these documents electronically? And the answer is, it depends. If the employee's position requires reliance on email, internet, and computer systems, you can email the ERISA documents to the employees so long as that email contains specific information regarding the attached ERISA documents. If you are a hub client, we can provide you with that sample email language. Employees who do not have a job that includes email or computer as an integral part of the job may sign a consent form to receive the documents electronically. The consent form must include very specific language and allow employees to provide an email address of his or her choice. Again, if you are a hub client, we can provide you with a sample consent form. Employers who are able to deliver ERISA documents electronically must be able to demonstrate actual receipt. Therefore, it's a good idea to save your sent items in your email system. One very important note, employers frequently post notices and documents on an intranet site. Without more, this is essentially the equivalent of posting the document on a bulletin board in a break room, and it is not sufficient or compliant delivery. Employers must send an email with the required notice content and include a link to the intranet site, but may only do so for those eligible positions that we talked about previously. Now we turn to the 5,500. Employers that have 100 or more current or former enrolled employee participants in the first month of the plan year must file the Form 5500. The headcount requirement does not include dependents and/or spouses. The Form 5500 must be filed with the Department of Labor using the eFast electronic system within 7 months after the end of the plan year. Employers may file for a 60-day extension prior to that original filing deadline. The 5,500 information or contents comes from a document called the Schedule A, which is generally completed by the insurance carrier or the third-party administrator and provided to the employer and the broker of record. For funded plans, which are plans that are funded by a trust, the TPA or third-party administrator will also complete a document called a Schedule C. Really, though, most plans are not funded by a trust, and therefore the Schedule C is just not frequently required. It is really important to know, though, that the 5,500 has to be completed both timely and accurately. Inaccurate or incomplete 5,500s can, in some circumstances, constitute a complete filing failure for penalty purposes. The penalties for failure to file that 5,500 can be really exorbitant. The 2019 penalty is $2,194 for each day that the filing was required. However, there is good news. the IRS does provide a delinquent filer program that significantly limits and reduces an employer's financial exposure. So let's talk about that delinquent filer program. First and foremost, the delinquent filer program is only available to employers that self-identified and enter the program themselves. If a government agency discovers the failure, it's too late to enter that delinquent filer program. For large plans, the applicable penalty amount under the delinquent filer program is only $10 for each day that the annual report is filed past the original due date. That doesn't include extensions. The even better news is that the daily penalty is capped at a maximum of $2,000. In the case of more than one delinquent filing submission, the maximum penalty amount is $2,000 for each annual report, but it's capped at $4,000 per plan. Remember, I said that in 2019, the daily penalty is $2,194. But under the delinquent filer program, your maximum exposure could only be $4,000. So the delinquent filer program is a huge opportunity for employers to clean up 5500s and get right with the Department of Labor. Earlier, I had referenced funded plans, which are those plans funded by a trust. In addition to requiring a Schedule C for the 5500, funded plans also have an additional notice obligation. Employers with funded plans must create and distribute the summary of annual report. The SAR must be provided to all participants and beneficiaries and is subject to the ERISA delivery rules that we discussed in a previous section. This means that the SAR must be hand-delivered or mailed to the home. Employers with employees eligible for electronic delivery may provide the SAR in accordance with the electronic delivery rules. Remember that plans that are not funded by a trust do not have to provide the summary of annual report. Thank you so much for viewing this ERISA 101 training webinar. For more information on the topic, please watch the other sections of our training webinar series. You can also go to hubinternational.com, scroll to the bottom of the page, and click on Compliance Bulletins for additional writings on this topic.